Hello, everybody, and welcome to History/Law Bite number 180, dated February 10th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Sweatt versus Painter, 339 U.S. 629, 1950. Sweatt versus Painter was very important U.S. Supreme Court decision handed down in 1950. It, along with several other decisions of the era, laid the final nails in the coffin for segregation in higher education. Indeed, in Sweatt versus Painter, Mr. Heman Sweatt, a resident of the state of Texas, had applied for admission to the University of Texas School of Law and was otherwise declared entirely qualified except for one thing. He was an African American. And, of course, under the laws of the state of Texas at the time, African Americans were not allowed to attend University of Texas School of Law. No surprise there. So he filed suit against the school accordingly. And the trial judge stayed the case for 6 months to allow that the University of Texas build a separate school for African American students. That school would become the Texas State University for Negroes. It is now known as the Thurgood Marshall School of Law at Texas Southern University. Now, this other law school for African American students was to be done as required by the 14th Amendment's Equal Protection Clause, so that black students in the state of Texas could have an equal opportunity at a legal education, same as whites. However, this school, was anything but equal, to the University of Texas School of Law. And for sure, in each and every single way that could be imagined, it was inferior to the law school that whites were allowed to attend, As such, Mr. Sweatt was not satisfied with these conditions at all, nor should he have been. So the matter went back, to state court and then ultimately to federal court and made its way all the way to the Supreme Court of the United States. In a logical position, giving so many precedents that couldn't be forwarded in any other direction, the Supreme Court, had to address a very simple question, and that was whether or not this separate but equal school was truly equal and met the requirements for equal protection of the laws. Did this school offer African American law students in Texas an equal education in the law, same as whites, And the Supreme Court, in a 9-0 decision authored by Chief Justice Frederick Vinson, ruled absolutely not. Indeed, the inferior school created by the state of Texas for African American students to be trained in the law as well as other fields was anything but equal to the University of Texas School of Law for whites. The school was inferior with respect to professors, to its law library, to its moot court, to its general quality of instruction in general. Whatever you think of, arguably, in comparison to the all-white school, this school created for African American students was absolutely, positively inferior and therefore not acceptable under the law. And the Supreme Court held, more or less, that separate but equal treatment with respect to the law school admissions process was unconstitutional. Indeed, creating separate conditions, for African American students with respect to the law school admissions process was a violation of the 14th Amendment's Equal Protection Clause. Separate but equal facilities with respect to a legal education were declared to be inherently unequal, Separate facilities for black students, essentially regardless of how good or terrible they were. Under the scope of the court's decision, separate facilities in legal education were therefore from this decision declared unconstitutional. Okay, so in Sweatt versus Painter, the court finally stopped circling the runway and finally declared, with respect to law school education, separate facilities are inherently unequal. All right, black students applying to law school in the states had to be afforded the same admissions criteria and the same acceptability to attend the schools, as well as be able to attend the same facilities as white students. Okay, so in sum, the holding of the court here was that separate but equal doctrine as applied to law schools was entirely unconstitutional. Black students applying to law schools had to be afforded the same admissions criteria, all right, as well as had to be afforded the ability to attend the same law schools as whites, all right. This case thus put an end to separate but equal with respect to law school education, all right. This case was decided on the same day as the decision in McLaurin versus Oklahoma State Regents, which had a similar declaration that this separate but equal treatment is unconstitutional with respect to other types of graduate education. McLaurin versus Oklahoma State Regents is, of course, covered in another video of mine, all right? In that case, Mr. McLaurin was applying to a PhD program, what was similarly denied on account of his race, all right? So these two cases decided on the same day, June 5th, 1950, essentially declared Jim Crow to be no longer constitutionally acceptable in higher education, whether it be law or medicine or graduate school, period, all right? These two cases declared the death knell for racial segregation in graduate school education, law, PhD, anything, all right? These cases put an end to that officially anyway, all right? So they are very important with respect to the end of racial segregation in higher education at public universities in the United States, and were certainly stepping stones on the path to Brown versus Board of Education in 1954. All right. So again, this case is Sweatt versus Painter, 339 U.S. 629, 1950. Racial segregation with respect to law school admissions violated the 14th Amendment to the U.S. Constitution, guaranteeing equal protection of the laws. Racial segregation in law school facilities and admission was no longer acceptable under the 14th Amendment's Equal Protection Clause under the decision in Sweatt versus Painter, 1950. Okay? So any questions or controversies, leave them down below and I'll be happy to answer them. All right? If you have not subscribed to my channel, please just hit that little red subscribe button and that little bell, and we will be in business. I thank you so much for listening to this video, and I hope you learned a thing or two from it. All right? Take care, stay safe out there, and I'll talk to you at the next bite. Peace.